And therefore, the statement of paragraph 8 is important. That this exemption provides that nothing in clause 3 shall apply to any person or class of person exempted from any provision of the subclause to the extent of such exemption. It will be seen that the control order nowhere indicates what the grounds of exemption are, nor have any rules framed for on this point, and unrestricted. Now we face the other word. The unrestricted power has been given to the state controller to make exemptions, and even he acts arbitrarily or for improper motives. There is no check over it and there is no way of obtaining redress. Therefore, 3.2b, so 2b, which we referred in the earlier video, is prima facie unreasonable. So this is the conclusion of the court. Now for the next part, in the facts of the case, it was mentioned that if the state controller is revoking, suspending a license, then he has to record reasons for such an action. Now, whether recording of reasons is a check on the unrestricted power of the state court controller is a question to be decided. Now, what the court has said in this is important. So, we'll see that it seems to us that such provision cannot be held to be reasonable. Why? No rules have been framed and no direction given on these matters to regulate or guide the discretion of the licensing officer. Okay, practically, the order commits to the unrestrained will of a single individual the power to grant or withhold the licenses in any way he chooses, and there is nothing in the order which would ensure a proper execution of the power or operate as a check upon injustice that might result from improper execution of the same. Now, the next portion is important, that the recording of reasons, this safeguard is hardly effective, for there is no higher authority prescribed in the order. For example, if the provision said that such a reason has to be recorded and that will be a ground for challenge under certain authority, if that was mentioned in the statute, then the relevance of the reasons which have been recorded will come up. But if there is no authority where the redressal could be claimed, then the reasons which are recorded will be of no use. Therefore, the reasons which are required to be recorded are only for the personal or subjective satisfaction of the licensing authority and not for furnishing any remedy to the aggrieved person. Therefore, now you have come across all the words which we referred to, that is unrestricted, unguided, unfettered, unregulated, and uncontrolled. Now, all these words means that such a provision is arbitrary if all these un are present in the statute. Now, it is important to also see what Justice Matthews has said while delivering a judgment in an American case, which is provided in the paragraph. Now, the words are that the action or non-action of the officers placed in such position may proceed from either enmity or prejudice, from partisan zeal or animosity, from favoritism and other improper influences and motives which are easy of concealment and difficult to be detected and exposed. Now, what the particular officer is having in his mind, is he having any favorable intention? Is he having any zealous intention or enmity or animosity? It cannot be gathered. So, whatever is in his mind will stay in his mind. Therefore, it is easy to be concealing it, and it is also difficult to be detected. Therefore, if these instances are present in the statute where such a reading cannot be taking place with a reasonable discretion, then injustice is writ large in the act. Therefore, it is said that consequently the injustice capable of being wrought under cover of such unrestricted power becomes apparent to every man without the necessity of detailed investigation. So, this will be the close for this particular case, but the next case is also based on the same situation. So, I'll tell you this case in a brief, but you have to remember whatever we learned in the previous case. Now, the fact of this case is that state of Tamil Nadu passed an act which was for the regulations of private educational institution. So, these private educational institutions will be requiring permission from a competent authority. So, now important is that there will be a competent authority and it will grant permission for running of the educational institution. Now, for the grant, there is a requirement of application. So, the private educational institutions will apply for permission. In the application, these are the ingredients which have to be, or particulars that have to be mentioned. Now, after mentioning these particulars, the application will be sent to the competent authority, and the competent authority then under section 4 may either grant or refuse to grant the permission, taking into consideration the particulars contained in such application. So, it is said that whatever is mentioned in this application, that will be the ground of granting or refusing of permissions. The second thing which was stated is that if the permission is refused, there is also a provision for making a representation. So, the other party will be heard. Now, if the permission is refused, then half of the fee is to be returned. Now, these are the provisions which are present in the Act. Now, next also what is important is section 22, the power to exempt. So, similarly to the facts of the earlier case, that the competent authority here is the state, the government, which by notification exempt any private educational institution or class of private educational institutions from the provisions of this Act. So, the government is having the power to exempt in this particular matter. Now, for example, a permission was refused for getting it recognized under the Act for a private educational institutions. Then you will challenge this particular Act. Now, what you have to see is whether there is uncontrolled, unrestricted, unguided, unfettered powers mentioned in the Act. Does the state government or the officers under the Act enjoy discretion, for which there is no rules prescribed, for which there is no principle prescribed, for which there is no check and redressal options. So this will have to be seen. So try to see whether these factors are present in these particular provisions. The court in this case said that it is well established that the main legislative function is the determination of policy. Now, that is the essential function of the legislature. Now, what the delegated authority has to do, it says it has only the task of implementing the object of the act. Task of implementing the objective of the act, because the legislature has laid down adequate guidelines for the exercise of power. So, the executive in this case will only implement the object of the act, and the guidelines and the policy has already been decided. Now, the policy in this particular case is granting of permission or refusing permission for private educational institutions. Now, this is the object. Now, how that object has to be fulfilled is a question. Now, it is stated that the purpose of the act is set to regulate the private educational institutions. Purpose is clear, but does not give any idea as to the manner in which the control over the institutions can be exercised. So, you have only told the purpose, but you have not told the manner in which it has to be exercised. Further, but the question is as to how this objective can be achieved. Section 6, which empowers the competent authority to grant or refuse to grant the permission of the establishing and running of institution, does not give any idea as to the conditions which it has to fulfill before it can apply for permission under the act. Now, it is said that you have to mention these particulars, but it is not mentioned in the act that these particular has to be mandatorily present in the educational institutions. It is only said that it will take into consideration these particulars, but it is never said that these are the guiding principles on which the application of the permission will be accepted. Now, therefore, it is said that the authority concerned has been left with unrestricted and unguided discretion, which renders the provisions unfair and discriminatory. Further, it may be noted that the Act, beyond requiring the applicant to make a factual statement about these matters, about the particulars, does not direct the institution to make provisions for them as conditions for grant of permission. So, again, going back, these particulars are not said to be the conditions on which the application will be granted or the permission will be granted. It is just said that every such application shall contain the following particulars. Now, the application has to contain the following particulars, but whether the educational institution is having all those or is mandatorily required to be having those is not mentioned in the Act. So, these give unrestricted, unrestrained, unfettered, unguided, uncontrolled power to the authority to either grant the permission or refuse the permission. Therefore, but there are no indication whatsoever about the legislative policy or the accepted rule of conduct on the vital issue about the maintenance of academic standard of the institution and other requirements relating to the building, library and necessary amenities for the students, as the Act is absolutely silent about the criteria to be adopted by the prescribed authority for granting or refusing permissions. So, no criteria is also mentioned, nor there is a detailed regulation about the amenities which have to be present in the educational institutions. Therefore, it is again saying the dangers of arbitrariness is enhanced by the unrestricted and unguided discretion vested in the state government in the choice of competent authority defined in section 2C. So when it was said that the government can then choose any authority, it also does not say who will be that any other authority, who will be the members constituting that any other authority. So no guiding principle is provided. On the question of the opportunity of being heard, the court said that it by itself does not protect the applicant from discriminatory treatment. So we have seen all the words now. So unrestricted, unrestrained, unguided, uncontrolled. But what is left is picking and choosing. Now this word is also generally used and it is mentioned in paragraph 8. So now see, it says that the provisions of the Act indicate that the state government has been vested with unrestricted discretion in the matter of choice of the competent authority under section 2C, as also in picking and choosing the institution for exemption from the Act. Therefore, now you have all the words, and the last statement will be that all these words, if it can be seen under an act, then that act will become arbitrary and hence against the concept of equality mentioned or the concept of fairness mentioned in Article 14.